Enga mana, enga reo, enga reo rangatira, onge hoe wha, tēnā koutou, tēnā koutou, tēnā koutou katoa. I'd like to acknowledge Chief Justice, your honours, friends and faculty of the law school and the university. I want to extend a particularly warm welcome to Ian's family and friends who I know are in the audience this evening. I'm Professor Brian E. James. I'm the Provost here at Te Herenga Waka and also for this week Acting Vice-Chancellor, which is why you get me, not Professor Nick Smith. But his loss is definitely my gain, as it's my very great privilege to welcome you all here this evening for what I know will be a thought-provoking lecture. And it is my very great pleasure to introduce our speaker today, Professor Rosalind Dixon, Anthony Mason Professor and Scientia Professor of Law. Ros is Director of the Gilbert and Tobin Centre of Public Law at the University of New South Wales. She earned her BA and LLB from UNSW and was an associate, what we would call a judge's clerk, to the then Chief Justice of Australia, the Honourable Murray Gleeson. She went on to attend Harvard Law before finding her way home again, but she is a truly global scholar, regularly invited to speak at universities and other institutions around the world. And while she's a global figure, she's cherished more locally for her generosity of spirit and offering kind and constructive feedback and advice to PhD students. She runs winter schools for early career researchers, and she catalyses those intellectual connections that we all treasure in our academic lives. Notably, she also challenges her discipline, all disciplines, to become more inclusive. She was on the advisory board of Equality Now and is as a director of New South Wales Pathways to Politics for Women. She writes compellingly in the media in defence of democracy, and goodness knows that needs all the defenders it can get right now. I know I speak for all of us in saying how honoured we are to hear her speak tonight, but before we get into tonight's lecture, I would like to take a moment to reflect on Ian Borrin's significant contributions. This Borrin lecture is just one of many ways his name is living on within the faculty and within the New Zealand legal community. Ian, who we are proud to say, of course, was a Victoria alumnus, practiced law in Wellington before being appointed to the District Court, Family Court, and later in his career, the Police Complaints Authority. And we're very pleased the family is represented here tonight by Mark George. Ian was enthusiastic about the idea of inviting an overseas scholar to share their expertise with our community and participate in the faculty's academic life. And so we all have the pleasure this evening of listening to a world-leading scholar, and I'm very happy on behalf of all of us to welcome Professor Rosalind Dixon to the lecture.
Enga tini reo e hui nei, e ngā mana o te huine nei, e mihi hana tēnei wahi nei, o te whenua moe moea kia koto. Tēnā koto, tēnā koto, tēnā tato katoa. I thank Justice Williams for helping me in my early journey to a proper opening to these remarks this evening. I want to begin, I think I might need some help from Leah in making it not in non-slide mode. I want to begin by saying what an honour it is to be here in Wellington and at this amazing university. There are very few cities in the world where you have such a world-class university, literally hundreds of metres from all the branches of government. And being here this week, I have been the great beneficiary of that. Managed to pop in and watch oral argument in a fascinating and important appeal, meet with colleagues who are literally running across the street to testify on a critically important bill, pay my respects to members of the judiciary, learn from colleagues in practice, all within a stone's throw. And I said to the students that I was lucky enough to meet with what a special thing that is, and how I think it really infuses a sense of Wellington as a legal community that is extremely cohesive and where ideas do flow between the academy and the profession and the broader community in a way that's quite unique and singular. I think that Ian Borrin, from what I understand of him, was a champion of that and would be proud to think about that as a continuing part of the community that he contributed to. I've learned a lot about him talking to Mark and Jenny and hearing stories from Greg last night and from Justice Goddard, who is a cousin and chair of the Michael and Suzanne Borrin Foundation. And from what I've learned, I think we should remember Ian for his commitment to his family and his friends. I was very generous of Jenny to host us last night, Mark, and what a delight it was to meet your mum and to hear more stories about Ian. And he had a strong sense of this country as one to be cherished and this city as well. Of course, he was also a lawyer. He was a judge. He was, as our provost has told us, someone who served in an accountability institution, which tonight I'm going to call a fourth branch institution. And through his life and work and also his gifts to the law school and the legal community and the foundation he helped establish, deeply committed to the rule of law. The rule of law depends on a whole range of institutions, as I'm going to talk about tonight. But it also has a connection and a close connection to legal education. The way we teach our law students, not only to be excellent, but to be critical, to be brave in the face of challenge. Think about the decisions that some US firms have made in recent times. Some of those decisions were very brave in standing up to the Trump administration, some were not. Those decisions will shape the policies and practices of the presidency in the United States for some years to come. Legal education, however, is also connected to the research and advocacy that professors and scholars, my colleagues visiting from Australia, here in New Zealand and others in the room do in advocating for ideas. And Professor Vicky Jackson of the Harvard Law School has talked about universities as knowledge institutions that contribute to democracy and the rule of law. So for a lawyer like Ian to understand that giving his generous funds to the Law Journal or the Law Review and to having scholarly exchange of the kind that I've been privileged to be part of this week is to understand the role that legal institutions and universities play in a strong democracy committed to the rule of law. My understanding is that Ian shared a love with Jenny and Mark and his family of skiing, a sport at which I'm utterly horrible, but he also secretly cherished a passion for cricket. And as a former member of the West Australian cricket team, I commend his good taste in that regard. The Borrin Lecture, in the generosity of the Borrin family and the foundation in its many different respects, is an ongoing multi-year dialogue. And I note that there have been stellar lectures given in recent years by Professors Kavanagh and Lee most recently. But I'm a debater at heart, so even in praising their contributions and lectures, I'm going to be engaging Professor Kavanagh a little bit in debate this evening. I understand she might be watching online, and we have an ongoing, very friendly but vigorous dialogue about what polyvocalism might mean in practice. So what do we mean by the idea of polyvocality in public law? It means a recognition of the fact and importance of a range of voices and institutions in the construction and implementation of our public law. Firstly, in terms of horizontal understandings of the separation of powers, it means understanding the important role that courts always understood to play an important role, but also the legislature, the executive, and what Professor Mark Tushnet calls the fourth branch of government, or Professor Tarun Kaitan, guarantor institutions play in both interpreting the law and enforcing it. But interpretation is the most controversial part of that claim. And the understanding that we are increasingly seeing is that all of these institutions must be given some role when we want to see how the Constitution operates in practice. The second claim is that increasingly constitutional norms, small c and capital C, are shaped by multiple levels of government, for better and worse, through devolved systems of government and local government, through formal federal structures or informal mechanisms of devolution, and increasingly by transnational norms, whether it be intergovernmental organisations or formal international legal instruments, or the overlay of bilateral investment treaty arbitration and other forms of transnational governance that are shaping our domestic public law. For better or worse, these voices shape our public arrangements and law in ways that we need to take account of and understand. There is also a dimension to the idea of polyvocality that emphasises that institutions are critical and central to our public law and governance, but that the people themselves, directly, unmediated, in the streets, in civil society, in their communities, do have a role in shaping our public law. And that a proper account of constitutionalism needs to take account of both the representative, the institutional, and the popular. And of course, as would be obvious and apparent in New Zealand, polyvocality also embraces an understanding of legal pluralism, of voices that come from different traditions and different sources of law, an understanding that the state is not the only source of governance that claims a form of constitutional status, in ways in New Zealand that draw our attention to the importance of tikanga and to the ways in which iwi governance and elders play an important role in shaping a pluralist constitutional order. Of course, there are also actors who might be seeking to contribute to a polyvocal order, who are large corporations, private actors with large means, self-funded billionaires, AI companies who do not wish to see their platforms regulated. Not all forms of polyvocality are desirable or to be embraced, but they are to be grappled with. Most forms of polyvocality arise in respect of some or other aspect of what could be described as a multi-dimensional constitution. People often think of New Zealand and the United Kingdom as unusual constitutionally for the lack of a canonical written constitution. But I think increasingly comparative constitutional lawyers understand that New Zealand and the UK are the norm and the rest of the world is the exception, insofar as you have always understood that constitutions are multidimensional. They comprise the common law, convention, statute and international norms. And it's taken the rest of the world decades to catch on to the idea that that is also true in systems with a canonical written constitution. And the fact of polyvocality arises in part from the multi-dimensional nature of a constitutional order. The common law is driven in its articulation by the courts. Convention is driven in its articulation by the accumulation of executive practice and the advice and actions of executive actors and the fourth branch or set of independent institutions that comprise together a range of executive and independent institutions in a society. Scholars play a role in interpreting and codifying convention, but convention has a claim in part because of the importance of the executive in polyvocal constitutional arrangements. Statutes, of course, invite our attention to the role of the legislature, but also to the courts and the fourth branch in interpretation and implementation of statute. And international law to the role of the executive in committing a country to certain norms, and absent legislation to the courts in using those norms as it may be in interpretation in certain cases or the development of the common law in others. The stronger claim for polyvocality is there's something desirable about having this kind of diffusion or distribution of authority in the implementation and interpretation of a constitution. That if you think about the courts alone, you have too narrow a compass for thinking about what an effective constitutional order looks like. Courts consider a very small portion of the issues of public law that govern our lives. Most of the cases that come before the court are the hard cases, the difficult ones, the ones that the Crown perhaps did not foresee or circumstance changed in ways that were not in the contemplation of the advice the government received at the time of proposing legislation. Understanding the role of Crown lawyers, of those in the executive branch and in the legislative branch in shaping our constitutional order is critical to understand an effective constitutional order that creates a seamless web of the rule of law. but also ex post when courts face difficult cases where there are likely to be private individuals or state actors unlikely to comply with a court order. It is critically important that the court has other institutions it can call upon, not only the bailiff, but the Parliament or the fourth branch or civil society or legal movements or lawyers, societies and individually to support the court's orders. And so to think about coverage but also compliance as deeply connected to a polyvocal understanding. I was saying earlier to the Chief Justice that I am a committed law and economics person in some deep way, and so cannot resist using the language of comparative advantage to suggest that there are also institutional strengths and weaknesses of different parts of this map that give us some additional reason to emphasise the importance of understanding each of these aspects of the map or the polyvocal terrain as having interpretive authority and responsibility. The people are closer to their community. The legislature has incentives and mechanisms for finding out what people on the ground really think. The fourth branch has expertise. It has the capacity to reason in ways that learn from the past and from other countries. The courts have the benefit of argument and time, reflection, and often the ability to look at certain issues with the benefit of hindsight. All of these things can be put together to see why combining institutional perspectives is a better way of understanding constitutionalism than a more singular, univocal, court-centric approach. There are some people at present in the United States, such as Professor Samuel Moyne, who wish to emphasise what I would call a strongly anti-court view. Professor Knight's supervisor, Professor Martin Lachlan, wrote a well-known book against constitutionalism where he tells you that courts are an unhelpful and unnecessary part of constitutional terrains and enforcement. I strongly disagree. Courts are critically important in ways that I'll talk about more this evening, but they are not the only important actor. And the importance of a polyvocal theory and account is one to emphasise the centrality of courts to the rule of law and to our constitutional democracy, but that they work best when they work in partnership and in a broader terrain where a range of institutions have authority and responsibility for the construction and implementation of a democratic constitutional order. Saying that, of course, is to invite attention to my third claim, which is that a polyvocal order is a more legitimate one in democratic terms than one that is more univocal. And by univocal, I mean either one that premises its order on a very strong view of legislative supremacy, unmodified by the important constraints that judicial review and the fourth branch can impose on legislative decision-making, or one that is radically court-centric and sees courts as the sole repository of authority for the interpretation and implementation of the Constitution. One of the central commitments in polyvocal accounts is the fact of reasonable disagreement about a range of norms. And the fact of that disagreement requires us, if we are committed, as Jeremy Waldron, this great New Zealand legal thinker, reminds us, to respecting the views of our fellow citizens, we need to embrace the authority of the Parliament as well as the ordinary voter in some areas of constitutional discourse. If we think about some of the cases from New Zealand that might have occupied those in the room as counsel, as advisors, as judges, and I offer these thoughts with great hesitation because I'm sure I've read them wrong. I thank Dean, Knight, Eddie, Clark and Jason Verhoes for telling me what I got right and the rest I got wrong by myself. So, of course, Borrowdale was a case that you'll be familiar with, which involved a challenge to aspects of the lockdown restrictions imposed in New Zealand during the COVID-19 pandemic. A polyvocal view makes us pay attention to the many voices that contributed to shaping those orders and to the regime that New Zealanders lived under. Public health officials played a very critically important role in ways that enhanced effectiveness and legitimacy in epistemic terms. The Prime Minister acted on their advice. But police, academics and civil society did raise questions, and the civil service in particular, government lawyers would be my summation, although I'm guessing, about the appropriateness and legality of acting on a prime ministerial direction without legal form. And then, the next step was to enact public health orders and finally legislation. And if you think about polyvocality, you pay attention to all those steps in the chain of ensuring a timely response. The Prime Minister's, if you like, exhortation from the woolly pulpit of the Prime Ministership allowed for an effective and timely response. But over time, the legal instantiation of these understandings in the public health orders and in law allowed for appropriate enforcement. And of course, democratic legitimacy, because public health orders are subject to legal challenge. Legislation is subject to debate and deliberation, albeit in the cabin way that was possible during COVID. If we think about the Fitzgerald case, which has occupied a number of the judges and lawyers in the room, the 3 strikes law that was at issue in this case and mandatory minimum sentences, we can again see the virtue of taking a polyvocal lens. The legislators who passed that law made a contribution to shaping New Zealand public law for better or for worse. But how those laws were enforced also depended on the prosecutorial exercise of discretion, on trial and appellate judges, and then, of course, those laws were repealed and then reenacted with relevant exceptions in ways that brought the legislature into the constitutional conversation. One of the things that was ventilated in litigation in this area was the potential for a mandatory set of minimum sentences to apply in grossly disproportionate ways in certain circumstances. That is what in my own work I would call a blind spot of accommodation in the legislative process. And one of the things that was raised in argument, as I understand it, was that could have been dealt with either at the level of prosecutorial discretion or at the level of judicial interpretation. A polyvocal account would not privilege either of those as the only available solution to disproportionate application. It would suggest either or both are necessary and available ways of responding to disproportionate applications of law, and both should be embraced in our conception of the separation of powers. Another recent and interesting and important case in New Zealand public law arises in the Trans-Tasman Resources case in relation to a controversy about deep sea mining. In that case, attention can be drawn to multiple sources of law, not only to the common law and statute, but also to the Treaty of Waitangi and Tikanga as relevant to the decision-making process about the granting or non-granting of permission for deep-sea extraction. Of course, multiple voices played a role in shaping the regulatory regime: the local government, the iwi, the EPA lower courts, and then the courts of appeal. And it was important to the legitimacy of the outcome reached that different perspectives and values were considered. Expert considerations through the EPA, democratic considerations through the local government, pluralist conceptions of law and authority through the iwi process, but legality as another layer added by the courts. You could make a similar argument in relation to the recent decisions in the Ellis case, which raised questions about the role of tikanga in questions of ongoing criminal liability in an instance of a deceased accused. Another instance where I think the polyvocal metaphor has some value in New Zealand is in the case that involved a question about the ability of a Maori authority, the Matakana, to access data on vaccination during COVID as a means of promoting effective vaccination among the Maori community. And as Dean notes, the way in which the court conceptualised that issue was about polyvocality and the sharing of governance between government and Maori under treaty in order to promote effectiveness and legitimacy, perceived and actual, in COVID governance. Polyvocality, as understood so far, might be considered relatively uncontroversial. not entirely uncontroversial, but relatively. The harder questions tend to arise when one thinks about the competition of voices. What if we don't agree? And there are three mediating principles that might be offered in this context. One is collaboration, which was the subject of Professor Kavanagh's lecture 2 years ago. The second is accountability, and the third is contestation. These are what you might call meta-principles or mediating principles. They are not to displace or downplay the importance of substantive values: democracy, dignity, equality, autonomy, solidarity, stability, effectiveness as its own claim. But as macro or meta-principles, they help us think about the ways in which different institutions and different voices interact. You can also see traces of these in New Zealand decisions that I have drawn your attention to on those slides. Part of how we account for the balance depends on the local tradition and jurisprudence and the text or relevant instrument that we are interpreting. But I want to suggest there are three broad architectural responses to the mediation exercise. One is what you might call a categorical approach that says one of those three values, remember they are, wrong way, accountability, contestation, transparency, should be someone's going to have to help me. I was doing well. One of them should take categorical priority. We just say accountability is the most important. Well, that would be legal constitutionalist. Or political accountability is the most important. Which might be something that is closer to contestation. One way of reading Professor Kavanagh's very important book, The Collaborative Constitution, is as suggesting that collaboration takes priority. I don't actually think, as I'm about to explain, that's the right way of reading her book. But if you understand it that way, and some people certainly do, I think it gives too much weight to collaboration over accountability and contestation. One of the metaphors she uses in her book is about marriage, and she suggests that the relationship between the courts and the legislature and the executive could be seen as something akin to marriage. And my submission is that the relationship is closer to being a parent at times if you are the court. And that requires you to enforce limits in the interests of legality and accountability that can be difficult and that the relevant people might push back on from time to time. But they are necessary limits, and they are limits not only that are to the benefit of the people you're enforcing them against, your children, but that society expects you to enforce, hence the analogy to the law that the court is required to uphold. So that legality and accountability are critically important values that are in some tension with too cosy a form of collaboration, both as a matter of role conception as well as in institutional design. Professor Kavanagh also suggests that we should think about the relationship as one of collegiality. When we are academics, we are not allowed to be judges, if you like, on our colleagues in our own institution. We can't peer review them. We can't decide whether they should be promoted immediately. We are in some way separated out from judgment because we're colleagues. You know, we're a part of a big dysfunctional family. And dysfunctional families are not allowed to be jurors and judges on their family members. So when we do peer review, we do it with impartiality and distance, with independence. We do it for other institutions, other countries, other law schools. And I think that's an important reminder of how important independence and impartiality are to conceptualising the fourth branch and the judicial role that cannot be undermined by too sort of literal an understanding of collaboration. The other way in which the use of the word collaboration concerns me is that we live in difficult times for democracy and the rule of law. Collaboration is different from being a collaborateur, but the origins of that word should remind us that standing up for democratic values, human rights and the rule of law can sometimes require us to stand against very strong pressures from the executive and in ways that are deeply uncomfortable and often called out as uncooperative, uncollaborative, being difficult. And if you think about the importance of protecting institutions, when Trump responds to court decisions that are irritants, he treats them as disloyal or uncollaborative, when really they are upholding the rule of law. So it is my argument that collaboration is important, and it is an important constitutional value, but it is not to be understood as categorically taking priority over other values, such as accountability or contestation, or as compromising in any way our commitment to independence and impartiality and to vigorous contestation. One of our roles as scholars is to criticise what we regard as the misuse of public power. It's not being impolite, it's doing our job. One of the jobs of the courts is to hold the executive to account. It is not a failure of collaboration, it is a commitment to impartiality and accountability. I believe Professor Kavanagh agrees with me, but I don't think we should read her book casually without noticing the difference between the model and the value. Both Alison Young of Cambridge and Professor Kavanagh ultimately, I think, embrace a form of balancing of all three values that I outlined, which I think is welcome. But I still am not satisfied because I think we need a structured way of doing this balancing that makes sure that we get the balance as close to right as possible based on the circumstances. In this context, I would also commend to you a very important recent book by Professor Cora Chan of Hong Kong University, who lays out a very structured and very thoughtful form of balancing for human rights. It's a bit too complicated even for me, but it's excellent and very worth your attention. Let me explain to you what the stakes might be. So everyone knows about Brexit. Not everyone reminds themselves of the facts of it every day, but in the latter period of the Brexit process, Prime Minister Boris Johnson was very committed to getting Brexit done despite the opposition of members of the Parliament and sought to prorogue Parliament by lying to the Queen. And in lying to the Queen, he was breaching a fundamental kind of convention, and he also undermined the supervisory role that Parliament plays in a polyvocal constitutional order. If you take an ad hoc balancing approach, you might be somewhat confused as to the outcome of this case. On the one hand, Professor Kavanagh says that restraint, comity, and a limit to the judicial role is part of collaboration. It involves slowdowns, not showdowns. Now, that's consistent with Brexit, but it's not consistent with the reception it received in the newspapers the day after the Supreme Court rendered these decisions. It was seen as a showdown. On the other hand, the effect of the Supreme Court of the United Kingdom saying, no, Boris, you can't do that. What you have done is subject to review and Parliament cannot be prorogued in the way that you have sought to do, promoted accountability and contestation. And the effect of the decision was collaborative because it joined the Parliament and the courts against an abusive executive. But my submission is it's hard to tell how that cashes out through an ad hoc balancing approach. And therefore I want to offer a more tiered approach to balancing these three critically important values: contestation, accountability, and collaboration. This approach involves differentiating between what Professor David Landau and I call the democratic minimum core and other thicker commitments to democracy, rights, deliberation, etc., which may be subject to reasonable disagreement. You'll see the requirements of the democratic minimum core there, which I explained to some of the colleagues in the room earlier in the week, but is designed to represent the minimum necessary conditions that all reasonable political theorists and all extant democracies would agree are necessary for the preservation of democracy. The one that Boris tried to undermine was the institutional checks and balances. And on that account, my submission is that it would be clear that by undermining the democratic minimum core, accountability and contestation took priority over collaboration, and that the court was right to step in that case, no matter how unusual the nature of the court's findings were, to enforce a kind of weak form basic structure doctrine that I draw in that context on the work of my friend Professor Erin Delaney. So why would I use this term polyvocality? Sounds like old wine in new bottles. The aim of what I am doing here is to invite those who reject the poles of parliamentary and judicial supremacy to join issue in having a genuine conversation about our similarities and our differences. There are lots of scholars around the world, Mark Tuschert, Stephen Gardbaum, Niels Peterson, Michaela Heilbronner, myself, Professor Kavanagh, Mark Tuschert, if I didn't mention him, all working in this tradition. But it's important that we see the areas of overlap as well as difference. So these polyvocality is rectangles, and everyone's theory underneath it is a square. It's a specific conception of polyvocality. So that we can shift the debate away from this simplistic either-or account of it's all Parliament or all the courts, which is just not empirically accurate or normatively attractive, to a more fine-grained debate about what version of polyvocal constitutional theory we are committed to. My submission is that the minimum that one must accept for polyvocality, as opposed to either judicial or legislative supremacy, is that legislative and executive actors are required to give at least minimum legal effect to a court decision. They are not entitled to ignore the narrowest ratio and order of a court. So Trump can't just say, you know what, let's leave him in El Salvador, why not? You know, that is not polyvocal. But at the same time, courts must be committed to allowing, either through formal design choices or their own jurisprudential choices, adequate scope for Parliament to contribute to polyvocal constitutionalism. Now, my preferred model of polyvocalism is outlined in a book called Responsive Judicial Review, which I published in 2023, and in a subsequent article in the Modern Law Review entitled The New Responsive Constitutionalism. That is not the title of my lecture tonight. So I'm only going to sketch in very brief terms before I hand over to Dean Maclay what my preferred polyvocal account looks like. It's one that embraces thin and thick democracy, the minimum core and things that are thicker, but in ways that are recognising the scope for reasonable disagreement about the thicker commitments. It's one that seeks to embrace and engage with theories of both positive and negative constitutionalism, of commitments to the rule of law, to a non-arbitrary state and effective government as equally important and subject to democratic contestation and implementation that must and will vary across countries, to both transformative and preservative models of constitutionalism as capable of enjoying implementation based on their degree of democratic support. It's a theory that's interested and attentive to timing, both in how constitutions are written, how they're interpreted, and how courts and legislative actors play their role in a polyvocal order. And it is also an account, like all theories of polyvocalism, that's interested in the distribution of authority, but in the context of a responsive account that seeks to emphasise the importance of pragmatic, prudential reasons for that distribution. Professor Kavanagh's account is primarily about principle, and mine is primarily about principle, but also practice as equally important. And you see the virtues of distributing authority in ways that I spoke to some colleagues about on Tuesday for guaranteeing against bad outcomes. Your provost is a distinguished engineer who can tell you about the importance in an earthquake of having more than one pillar for a building should one fail. That's often called the principle of redundancy in design. If you think about a case like Fitzgerald, if you think that the prosecutors should have declined to prosecute the third offence against the relevant defendant because it was not a sufficiently serious offence to warrant engagement of a mandatory minimum 7-year term, the courts were there as the safeguard in the event of that failure of a proper exercise of discretion. The other way in which distributing authority helps is that you can bolster each other. If one institution is under pressure, the other institution can step up, cite it, engage it, add its legitimacy to it in ways that can be meaningful. It is my prediction that the US Supreme Court cannot succeed in countering President Trump on the issues that matter most to him unless either the Senate or the House finds a way to support the court. That is what I mean by the cross-collateralisation idea, and comes back to the idea of collaboration as value, strategic and principled, rather than as model. For the judges in the room, responsive judicial review means paying attention to the argument for robust review, which is that parliaments get it wrong. They are subject to blind spots, to burdens of inertia, and to, in some cases, an executive bent on accumulating institutional and electoral authority. But there are dangers to judicial review, especially of the robust kind, that decisions can fail to respect reasonable democratic majority understandings and create new forms of inertia that are about a failure to respond to evolving democratic understandings. They can undermine the incentives of brave Crown law folks and their colleagues to actually interpret the law in ways that require the expenditure of political capital but are critically important to the maintenance of the rule of law. And they can provoke backlash, which are forms of attacks on courts and the rule of law which are dangerous for our society. So courts, in my opinion and submission, have to calibrate both the benefits and the risks to judicial review by adopting a mix of robust and restrained review according to the context. One that is eschewing any kind of categorical test that embraces calibrated proportionality on Borrin review, on Borrin review of executive action, and in relation to common law. So with all due respect to the Supreme Court judges in the audience, I would suggest that the test of the Court of Appeal in the GP group would be preferable to the one endorsed, a Wednesbury-style more rationality test in that case. And again, with respect to our judicial colleagues, suggest that the more categorical language in Chief of Defence Force that said that the deference owed to the military was enough to dispose of a Borrin challenge to mandatory vaccination could usefully have been augmented or modified by greater attention to the ways in which the military had reasoned. So it's in the judgment, which is the military thought really hard about whether to impose the mandate and what the implications would be for frontline combat if they didn't. They made very good efforts to protect people economically from a decision to exclude them from frontline combat and offered them ongoing protection. That kind of careful attention to consequences and alternatives is exactly the kind of calibration that would lead to deference in accordance with the result of the case. But it's less categorical. It's not we just defer to the military, it's more fine-grained. And it's there in the reasoning of the court, but it's not always emphasised in how we read and think about it because of certain aspects or passages. The broad brush reductionist account is one in which blind spots and burdens of inertia are often best countered through a mix of weak, strong review, whereas when there are threats to institutional pluralism or electoral pluralism, a higher degree of both coercive remedies, timely relief, and robust muscular reading may be required. But of course there are hybrids. The decision that this, has recently, exercised the minds of council and courts in New Zealand around the right of 16-year-olds to vote is a hybrid. It's not strictly the minimum core, but it involves voting rights in ways that mean it's not purely a story about blind spots or inertia. So one might end up with hybrids. If our time tonight were longer, I would also want to say a few things about declarations and the fact that it matters how courts weaken review to the ways in which the Parliament has an opportunity to re-engage the courts through a process of dialogue. But our time is limited. The last thing I want to say is about judicial statecraft. And this is normally the part of my remarks where I get booed and I run for the door. It is important to understand that in countries like Australia and New Zealand, we take the court's capacity to see its orders implemented largely for granted. In Pakistan, in Colombia, in Kenya, in South Africa even, in the United States, that is no longer the case. And one should always guard against that possibility. One of the things I think is very impressive that your courts do is commit to public education about the role of courts. I think that the legal community here does a great job of helping contribute to public discourse. Colleagues have been on the radio and about to go on the radio for that purpose. But I do think that courts themselves can bolster the chances that they can survive an attack in extreme cases by certain prudential techniques, and that they can improve public confidence in the rule of law and the judiciary by using these techniques in more ordinary times. That means using remedies that engage the government and civil society. It means prudence about the timing of certain decisions. It means adopting a tone of respect toward government. There are all these wonderful experiments that if you show respect to people in the workplace, they put people in labs and they've shown this to be extremely easily replicable, they'll work harder. You know, if your boss is an arsehole, you just basically check out realestate.com and go and get a lot of coffees. But if you are shown respect, you reciprocate. And if courts perform respect to the other branches of government are more likely to comply. And so courts should only call out bad faith when it's clear, and should otherwise credit other branches with good motives as much as possible. Courts should also use a mix of local and global narratives that's sensitive to context. In some isolationist countries, using global narratives is just a mistake. At the current political moment, one might reflect on that in New Zealand. But there are other times where drawing on the local and the global can bolster the perceived legitimacy. This is not about the reasoning and the core reasoning of a court. It's about how one frames obiter or aspects of the narrative aspect. One of your honours students Dougal is doing a terrific project on this. Narrative elements of judging that speak to how we persuade our fellow citizens. And finally, and most controversially, multi-member courts, when they know they are going to be facing disagreement, should select lead authors for their opinions who are relatable to the disappointed litigant. So if you are going to issue a decision in favour of gay rights, the most religious conservative member of the court should deliver it. If you are going to make an order against government that costs a lot of money, the member of the court who has worked in government and understands budgets should deliver it. Now, there's some face pulling already. I look forward to the face pulling continuing during questions. I do want to say that my effort here this evening is both to consolidate shared understandings between other Borrin lecturers and other very respected colleagues, but also to emphasise areas of difference, both in the weight given to different values and the way in which we seek to mediate them. I've tried to offer some thoughts that might be of some relevance in New Zealand, and to have an ascending degree of controversy in my remarks so that there's something for everyone to like and certainly something for everyone to hate. I really hope that the conversation continues next year in as vigorous a manner, and I am so grateful for the opportunity. I want to again thank the George and Thomas family and the Foundation and what Ian did in bringing me here, as well as Vic for hosting me, and say thank you to our distinguished guests for being here. It is an honour to speak with such a wonderful crowd, and I'm really, really grateful for the opportunity. Thank you.
Sorry, I'm not sure about the order of these, but my name's Ben Keith. I'm a barrister. I argued some of the cases you mentioned. One of the common threads in a number of the decisions you pointed to, including Miller, is simply that the court was able to say there's no evidence. So famously, no one was prepared to swear an affidavit about the prorogation of
Yes.
Parliament, partly because no one would have believed Boris Johnson, I think. But in most of the New Zealand decisions to which you've referred, make it 16,
Yes.
Te Pū Moetakana, is that a methodological out? Is it a sort of expert judicial tool in your model? How does that, just the Emperor's got nothing on, fit in? Thanks very much for a great lecture.
Excellent point, Ben. I think, relying on a lack of evidence is a way of softening the finality of a decision in a way that I think is to be embraced within a responsive or polyvocal account. I think sometimes it's actually just a pointed criticism of counsel. Why didn't you put on the evidence necessary to win your case? But most of the time at the ultimate appellate level, it's a soft way of resolving a dispute that leaves open the possibility that it could be revisited in future if the Parliament were to want to reenact something and the Executive would want to amass the evidence necessary to support a case in which it was subsequently challenged. So I did actually make a note of a couple of the cases which you've alluded to and where I thought that was a softening or a weakening of finality, which in general terms I think is to be embraced. Yes. Jacinta.
Thank you very much, Ros. Really fascinating. I noticed in your last slide you had points judicial statecraft. Given the nature of the topic, polyvocal, do you have similar suggestions for legislative statecraft or executive?
Oh, thank you for that question. Please write it yourself because Jacinta's a leading expert on legislation. I don't have precise suggestions, but I certainly think conceptually and logically there are suggestions to be made because the whole point is it's a symmetric claim about the importance of all these institutions working together. Now, sometimes, Professor Kavanagh talks about heterarchy. One of the things I want to insist on is sometimes there's hierarchy, actually, and accountability requires hierarchy. So it's not purely heterarchic. Polyvocality is not flat. My children recently said to me, I do not recognise your authority other than as a deliberative kind of claim. I'm like, I am your parent. Put your phone down. So there is some authority, so it's not purely symmetric, but I definitely think in terms of comity and tone, in terms of prudence and timing, don't kick a court when it's down or, don't fail to make respectful reference to its decisions if you're planning to modify it. And I think that one of the things about authorship is the kind of glue between institutions is more effectively maintained when there are people who have occupied multiple branches of government and where the people who are the spokespeople on difficult issues speak in ways that understand. So if you've had someone who's in Parliament who has deep knowledge of the workings of courts, they may or may not be the attorney, and they say, look, it's with regret that we have to do this, but we disagree with the courts and we respect what they've said, that's the respect prong, but this is why we're doing it, and the legal community in the courts will feel more able to see that as a policy change rather than a slap down in a way that's linked to authorship. But I would love you to help me think through that because I haven't done the work, but it's there to be done. Andrew.
Hi, Ros. Great lecture, and again to the Borrin Foundation, thank you so much from all of us in Wellington for supporting this series. It's never fails to thrill and bring us excellent people like yourself, Ros, to Wellington. We're very appreciative for that. My question is, one of the things I find a little frustrating, not about what you're saying,
that's all right,
but
Joey.
about these theories is often what they are is effectively directed to the legal community, and in particular the judicial community, telling judges, how they should think about their role. So it really is about testing, different ways of conceiving of the judicial role. Don't we really need to be focusing more attention on the other actors and getting their buy-in to some of the principles and so on that we're talking about here? Because it becomes one-sided in terms of how you conceptualize roles, then actually you end up speaking to the wrong audience.
I think that's right. Dr. Elizabeth Perriman, my colleague at New South and a graduate of it, runs this program with me in New South Wales called the Pathways to Politics for Women program. And one of the things we do is we bore our participants with public law and, insist that they should go into elected office understanding the basics of our system of government and human rights. And I say to them, this is not going to help you get elected, but it'll help you be a good member of Parliament. And that's what we're here for. We're not here to elect Marjorie Taylor Greene, So, yes, I do think so. But one of the things I think is we have to understand that as lawyers, our strength is in speaking to lawyers in a particular context, and we have to change hats to speak to members of the executive and the parliament. You know, one of my favourite mediums is talkback radio. I love it, and I do quite a bit of it. But I don't talk about polyvocal constitutionalism. But I write for the daily, paper in Sydney, and during COVID, I wrote a couple of op-eds where I managed to reference proportionality in the Taiwanese Constitutional Court. But my basic point was, mate, if some people are going to have harsher lockdowns, they should get some cash. So I think your criticism is extremely well made, but I would say you can't give the same message to every audience, and not all of us in the Academy are interested in or well placed to speak to all of our audiences. And I'm certainly better placed now by virtue of being an Australian living in Australia and the benefit of some grey hairs and experience to do the sort of broader work. I was an assistant professor at the University of Chicago. No one understood what I was talking about. My accent was just incomprehensible. And I didn't have the legitimacy to talk to the members of the state legislature. So everyone has to play their role according to where they are culturally, geographically, personally, and you have to use a different discourse. But I completely agree with you that the importance is, if you want the courts to play ball and give you space, how about you guys pay attention to the rule of law and to the Constitution and show them some respect? And I thought one of the things that was extremely positive in Australia in the recent memory was that, the opposition was attacking the government for its failure to anticipate a decision of the High Court in NZYQ, which was about the constitutional limits on the ability to continue to detain non-citizens indefinitely. And there were a number of statements by the then attorney Mark Dreyfus and other members of the government that did do the right thing and say, we're just upholding the Constitution and no one knows exactly what the court's going to do, but the court's entitled to do what's going to do and our job is to respond, and that's, you're mischaracterising. I thought that was very positive, and I certainly and other colleagues tried very hard to emphasise that understanding. So I agree with you, subject to those caveats.
I've noticed when I've been doing a little bit of comparative stuff lately and looking particularly at civil law jurisdictions, and one thing that stuck out to me constitutionally is that a lot of civil law jurisdictions have sort of substantive rights or what in some countries they call state goals baked into their constitutions. For example, Germany is defined constitutionally and inalterably as a social democratic state, which has normative connotations. We don't tend to have that in the common law world. We have these kind of formal ideals, but there's no particular purpose in mind, I suppose. People are meant to be able to figure it out for themselves. Do you think that lack of kind of agreed purpose or sort of end that the state is meant to achieve might contribute to this kind of inter-institutional, I'm not going to call it fighting, but pushing back against each other, and this kind of ad hoc approach that we take to these kind of balancing tests?
Very interesting question, Georgia. So I don't think the fight's bad. I think the fight is necessary, actually. That contestation, governance is not a corporate kind of smooth machine. The frictions in the system are about contestation and bringing different perspectives and different arguments to bear in a way that I think is part of the system working well. I do agree with Aileen when she says showdowns and slowdowns are different, but, government is supposed to be about constantly asking ourselves, can we do better? Why are we doing it this way? Can we make improvements? So that kind of conflictual dynamic is critically important. And it's critically important that people see it, because in an age of populism, people have this perception that we're all in this club, we're an elite club and we all just slap each other on the back and we never hold each other to account. And that's critically important that they see it and that we do it. So I think that the conflict is within bounds very important. I don't want to, characterise it as pathological. Yes, it is more important when values are contested that many actors contribute to articulating and shaping them over time. That is absolutely something I agree with, and is something that, we're having a conference tomorrow, something that we'll be emphasising in some of the papers. I do think, however, that the Germans claim determinacy for values that are indeterminate, and we underplay the determinacy of the common law tradition in articulating values within our systems. I have a project with Professor Attry at Oxford about constitutional values in comparative terms, where we try and say actually many systems have values, whether written or unwritten, and you can discern them from the path of jurisprudence. And, to just give you an illustration, the canonical founding value of Germany, and the basic law is dignity. Do we mean the dignity of the fetus or the dignity of the woman in the right to abortion? I mean, it's a completely contested idea. And so my submission would be that while your question is excellent and helpful, that the relationship between the civil law and other written constitutions like South Africa or Kenya that also have, founding values, and those like New Zealand and Australia that do not, it's not as big as your question suggests, because they're all contested in practice and at the concrete level of implementation.
Thank you so much for your lecture. My question is, you mentioned 3 mediators of substance in collaboration, accountability and contestation. I'm wondering how they relate to calibrated balancing or the democratic minimum core on a spectrum through to more thicker rights, and how that differentiates itself from an ad hoc approach where you've got 2 variable sort of things and you can't set one with the other. So how do you approach a baseline, or is simply the point that it should be a more narrative approach in general?
So it's a very thoughtful question, thank you. So in relation to the democratic minimum core, I think accountability is the primary value. You're not allowed to trash the democratic minimum core. We will hold you to account and we'll try and stop you. And collaboration comes in service of that goal as a prudential, pragmatic value. All hands on deck to prevent us trashing the minimum core through accountability. And collaboration isn't kumbaya collaboration, it's like, mate, we need your help. In respect of broader ideas of democracy, the right to abortion or not, the right to, vote for 16-year-olds, etc., it's more contestable, where contestation takes greater priority, and collaboration, if what we understand that to mean is giving some play in the joints for a range of institutions to play a role, more important. So the claim would be, under this approach, accountability and legality are presumptively given priority where anything affects the democratic minimum core, but that contestation and collaboration or weaker forms of review are given priority outside it. And it's no surprise as a result that there was a declaration in the Make It 16 case, and that is the subject of ongoing advocacy and contestation, and that's appropriate in my view. So I don't think I've got a perfect answer, but I think it is clearer how we would judge a court or how a court should be approaching an issue under a more tiered approach than in a fully balancing ad hoc approach.
I promise you won't be listening to me for 15 minutes. I just have a couple of jobs to do. First of all, to say welcome as the university administrator that I am now is very pleased to see that in 18 years we've got a future law student arriving at the law school. So thank you. We've got to make sure they come early.
He's very well educated.
And often. Even if it might be, he or she might be unfortunately biased towards public law as a result. But I just wanted to do a couple of things, and then I promise I'll sit down and you can go and have a drink. The first is to just acknowledge Ian. A number of things have been all said about Ian in relation to his donations to the law school and his donations to the legal profession in general. For me, although the donations are the reason we can do this, it's almost beside the point. Ian had a great faith in this law school, and he also had a kind of belief in me, which always gave me strength that I wouldn't otherwise have had. He believed that if you supported good people to do their work, even if he didn't necessarily understand what that work was, or didn't really get the point of some of the things that we might be talking about, he knew that we were good and that we would try hard to make use of his donations. I think we've done that consistently, and tonight is no different example. He also was the modicum of kindness. And since I'm standing here, I can tell you that while Ian is probably one of the greatest donors in the history of our university, what I will most remember from before is him helping me get out of a parallel park in Karori. So I remember this always. And kindness as a thing you might have already gathered is shared by Ros. After the dinner last night, she went home, went up to the room and then texted something back to us that she thought my son might be interested in. She didn't need to do that. She just wanted to be kind and nice and to make a difference for someone she actually hasn't met, which I think is speaks inordinately of her. I also just want to acknowledge my colleague, Dr. Knight, who I tried to get to stand here. Dean has organised this visit, probably a bit too much organised this visit, but it was his suggestion that Ros come. There's a connection between the Gilbert and Tobin Public Law Centre at UNSW and our own Centre of Public Law. I know that's been a source of past collaboration, but most importantly, a source of future collaborations. And in fact, from the moment Ros sat down in my room on Monday morning, we've been talking about future collaborations on various continents. And so thank you, Dean, for organising this visit. I just wanted to say something also about the topic. I'm not really qualified to talk about public law, as many of you know. We had a very robust seminar the other day where there was a common comment, why are we doing this? Why don't we just go out and defend democracy? And I think we should all just go out and defend democracy. But Ros made the point, and I think the really important point, that the value we add at our particular place is that we try and understand what we are going out to defend first. And other people can go to the barricades, but we go to barricades with footnotes. And that's as it should be, because we try to understand and we try to make sense. I'm not really competent to talk about polyvocal anything, right, Dean, or polycentrism. But what I would say is, on reflection, the last week has been somewhat disappointing in New Zealand because people have gone out to defend something or to attack something in relation to a very odd and I think deeply flawed piece of legislation. But rather than trying to understand why it's flawed or why it doesn't fit in with our constitution, a lot of both sides, the person who defends the bill and the people who attack it, have used caricatures of our country and our constitution and the way we do our government. And that seems, whatever happens to that bill, seems to me very unfortunate, because there are real problems with the Regulatory Standards Bill, but they're not many of the ones that have been identified by the more vocal contributors. And I'm very proud of the fact that at least 3 colleagues have gone and tried to enlighten MPs, even if the MPs were not, unfortunately, actually in the room, which is another thing we might talk about at drinks. Jeffrey, Dean and Eddie went across, or Eddie from his office actually, went to try and explain what was actually wrong about the Regulatory Standards Bill, or why the Regulatory Standards Bill could be improved. And that seems to me a core value of what we're going to do, and that's what Ros has been doing while she's been here. I just want to say something else about the nature of her visit. I'm the person who's responsible for Ian having given this money, I think, for this particular program. Many years ago, I spoke to Ian trying to use some of the models I had seen in North America of these visiting programs. And I said, what this place really needs is we have great people, but we need to bring in people, rather than going out into the world, bring people here to share their knowledge and their expertise. But also, most importantly, and Ros has shown this in spades, her enthusiasm for the academic enterprise. So what you don't know, those of you who haven't been in the law school for the last 4 days, is in a rather merciless program put together by Dr. Knight. Ros has done a huge number of seminars, not just for academics, which is very common on academic visits, or having lunch, which is even more common for academic visitors. But she's also, and this is a tribute to the fact the students are here, and the people that I think are most highly impressed by Ros are actually the students who have been to these seminars she's run about research methodologies and tried to inspire them. We have great students, and it's absolutely fantastic we've had Ros coming to inspire them. So if Ian could have seen what we've done, I think, 15 years after this was established, about now, he would be very proud, I think, and hopefully believe I'd sold him a good bill of goods. But thank you very much, Ros, and there are refreshments outside for everybody. Cheers.